Okay, can you hear me?
Yes, we can hear you.
Perfect. So in the last class, guys, I think the recording is up and running. In the last class, we talked about applications, and in terms of preparation of application, we prepared the applications. So the first one we talked about was an application under. Let me just try and project my screen so that we are all on the same page. I do not want us to be on different pages. I want us to always remain on the same page. All right, so I'm going to proceed and project my screen right there. All right, can you see the screen?
Nope.
Okay, the screen is up and I am on the interlocutory applications that is under topic 7. I hope you can see the screen very well because I think you can. So, okay. Now, if you can see my screen, we've been talking about interlocutory applications, or generally the interim applications. You call them interlocutory or interim. Simply means that they are applications or they are orders that you seek in the interim. Okay, you seek them in the interim as the suit is going. The interim to the suit, as the suit is proceeding, you put in an application to seek a temporary order. Okay. Now, if you look at that list, you can all bear me witness that we have been able to cover almost all of them. So we have talked about applications under Order 40, that is a temporary injunction. We have talked about applications under Order 39. This is Order 39, which is the Marevas and RS for judgment. We shall talk about Anton Pillars today. We have talked about interpleader proceedings. Okay. We have talked about third-party proceedings. We have talked about summary procedures, that is default judgment, and also summary procedures in itself. And then we've talked about striking out of pleadings or striking out of suits. So from this list, there are only 2 things that are remaining, but essentially there are 3. There are 3 things that we haven't talked about that I want us to talk about. The first one is an order of commission. The second one is Anton Pillar, which I'm going to explain right now, Anton Pillar. And then the third one is discovery and inspection. Now, which of these applications that I've highlighted on the screen is still not making sense to you? Is there anybody that is saying that this one is not making sense to me at all? I don't understand what it is. Guys?
Yeah, proceed, Malim. We are okay. We are okay.
Okay, then. So based on that, I think we are fine. We are fine to go. And I will just start the class off. And I want us to start from the discussion that we had in the last class. Now, in the last class, let me stop sharing the screen. In the last class, we talked about arrest before judgment, attachment before judgment, and orders of temporary injunctions. And we said that in such aspects, there are three orders that you can pray for all at the same time. You can pray for them all at the same time, but you need to understand what the examiner is looking for. What is the examiner asking you to do? That is what you need to understand. Okay? What are the facts of the issue? What are the facts that are provided within the issue, within the question that you're addressing? Are you together? So that is what we are saying. That is exactly what I'm saying. So you need at all times to understand that anytime the examiner is giving you a question and you're supposed to prepare an application, then the first thing you need to understand is what is the actual issue? What is the problem in the question? And then how do you address the question? And I said, when it comes to this application, there are two things. The first one, the examiner will be interested in you drafting. And we looked at 2021, question 1, that is June, and 2, actually question 1. And the first part of question 1, you were supposed to draft the application, where you drafted the application and included all the three orders. The second one is an instance where the examiner is not interested in you drafting, but the examiner wants you to give an advice or provide a ruling on the application that we did. So in that instance, also you must be able to sit down and understand not just how to draft them, but the contents and also a case or two if there's any. Okay? For instance, if you're talking about Mareva injunctions and you're talking about temporary injunction, you're talking about Anton Pila, you cannot fail to mention the locus classicus cases in that instance. Of course, Jella, Kasman, Brown will apply in all instances. The case of Jella versus Kasman. Are you together? So that is what I'm saying. So always also focus on understanding what is happening in this class. Okay. Jesus. All right. So like I was saying, also focus on understanding the content around the application, which is the most important thing. Okay? Which is the most important thing. Are you together? That is very, very important for you to understand. All right. Now let us go and talk about Anton Pila. So what is Anton Pila? Somebody tell me, what is Anton Pila? Guys, I said that when it comes to this application, the first thing you need to understand is what it is, when, stroke why you apply for it, and then how you apply for it, and then the grounds. Okay? So what is this thing called Anton Pila? Somebody, Anton Pila, we proceed to Anton Pila and then orders of formation, and then we can complete with discovery and inspection. Guys, Anton Pila. What do you understand Anton Pila to be? And what is the difference between Anton Pila and Mareva? Yes, Michael. What is Anton Pila?
Anton Pila is an enter and search order, while Mareva is a freezing order.
No? What is Anton Pila? Paris.
Okay, I had the same thought as the previous speaker. I believe the Anton Pila, it's a searching order.
No? Tianga, Jennifer?
I think Mareva is an interlocutory injunction, while Anton Pila is a mandatory injunction.
Mm-mm. Yes, Kamunyu.
Yeah. So how I understand Anton Pila is
by this example, where you probably have a copyright over maybe your music, and then
what is it? No. Yeah. Don't give an example. What is Anton Pila? I don't have a copyright. What is Anton Pila?
In fact, I just wanted to explain whatever everybody else was saying, that it's a search order, while Mareva is a freezing order.
No. Something important that you guys are leaving out. Penina, what is it? Tell me, what is being left out?
Yes, Mwalimu, what I understand by an Anton Pila is a court order that gives authority to a party to enter and search and seize evidence.
Exactly, that's the word that is missing. So it is not to search, not to just enter and search. No, it's not a search warrant. Okay? It is an order to search, not only to search, but to seize. Okay? You search and you seize. So that is what we are saying. You're not just searching, you search and you seize. So you enter, you search, and you seize. Guys, that is the whole difference. When you say it is an order to search, that is a search warrant. Okay? But Anton Pila does more than just searching. Okay? More than just searching. And most of the time, it is not even a search. Because one of the requirements that you must show, one of the requirements that you have to provide when you're applying for Anton Pila is that whatever you're going to pick is in that house. So you're not going to look for it. You're very sure that it is there. So you get into the house, you pick it. So enter, search, and seize. You have to seize it. Okay? That's what you're saying. That is exactly what Anton Pila is. So Mareva, you freeze something. You freeze a property. You freeze. A Mareva is a freezing order. Okay? Now, Anton Pila is an order that is issued by the court where the plaintiff or the defendant is seeking an order to enter the premises, search, and seize specific documents or items that are believed to be in that on that premise. So we are simply saying that any time where the certain properties that are believed to be in a specific property and you want to go get them before they are disposed, before they are transferred, then you can get Anton Pila, okay, to enter the place, search and seize whatever you will get that is relevant to the case. Okay, now just like Kamunyo was already explaining, that in certain instances, if you believe that somebody is infringing your copyright, they are printing your books in their houses, you can get Anton Pila, go to their house, search the house, and seize the books, and then bring them to court. Okay, whatever is seized is usually brought to court as evidence. So it's an order for searching and seizing. You seize. Are we together? You have to arrest what you are looking for. So it must be something that you believe to be there. So yes, it is an order of the court, but not just for search. For searching, of course, it gives you once you have the search, it gives you the entry permission. So you enter. Once you enter, then you search. Once you've searched, then you have to seize. Okay? So before you are given that order, there must be strong evidence that whatever you're looking for is actually in that house. Whatever you're looking for is actually in that house. Are you together? So that is what you're calling Anton Pila, is an order given by the court in the instance where the plaintiff or the applicant is seeking to search and seize specified items within a specified premise. So that is Anton Pila. You want an order to search and seize. Now, Anton Pila must be brought under certificate of urgency because it is urgent anyway. It must be brought under certificate of urgency. It must be brought under certificate of urgency. And normally, the evidence required, the burden or the threshold required is usually a little bit higher than the balance of probability. It is a little bit higher than the balance of probability. There needs to be strong evidence that whatever you're looking for is in that house. because without a strong evidence, you will not have an Anton Pillar order issued on your behalf, or in your favor. So that is Anton Pillar. So once you understand what Anton Pillar is, you understand why and when you apply for Anton Pillar. And I've already explained that you apply for Anton Pillar in the instance where there are items in the possession either of the plaintiff or the defendant that are relevant to the suit and they're believed to be in a specified place, and that unless they are collected, they will be destroyed. For instance, there are certain documents that are so crucial in your case, but you believe those documents are in the office of the defendant's office or the plaintiff's office, and you know very well if you don't get those documents, the defendant may destroy them. Okay, the defendant may destroy them. For instance, they could be employee documents. An employee has sued an employer, and the employer is intending to destroy the evidence, destroy documents. So in the instance where you're fearing for destruction of the evidence, then you run and get Anton Pillar. Anton Pillar allows you to go and seize that document and bring it before the court. Okay, you search and you seize it. Guys, are we moving together?
Yeah, kabisa.
Yes, Madam.
All right. That is perfect. That is Anton Pillar. Now, how do you incorporate Anton Pillar in your application? Now, I've said, guys, that this application is usually a notice of motion application all the time. All the time. It is usually a notice of motion application. It is usually a notice of motion application. The same application that we have been doing all the time is the same notice of motion, is the same application that you're going to do when it comes to Anton Pillar and all other applications. Notice of motion never changes. What will change are the prayers and the grounds. So you still have the same parties. Okay, you still have the same parties, the applicant and the respondent. You're still going to have your notice of motion. You're still going to have the rules you're coming under. You're still going to have your introductory statement. Take notice that this honorable court shall be moved on that day. And then the orders and then the grounds. Those are the things that will change. So let's assume that we are doing an application for Anton Pillar. Let us assume that we are doing an application for Anton Pillar. And I've said that when it comes to Anton Pillar, the evidence must be very strong. The evidence must be very strong so as to identify the documents or whatever items you are trying to seize and where they are. Okay? It is not a fishing expedition. The court will not give you an order of Anton Pillar if you're just trying to fish. You don't know whether they're there. You're just trying to see. Maybe you'll find them. No, you will not get an Anton Pillar in that instance. You must be able to tell the court that I know the documents are here and I have evidence to that effect. That is when you will get an Anton Pillar. That is the only time you're going to get an Anton Pillar. Are you together? Now, somebody tell me, what do I need to write here? So our applicant, in this case, is looking for Anton Pillar. Okay. What is our first prayer? Of course, I've said normally we bring it under certificate of urgency. So this application as urgent and service be dispensed with in the instance. That is the first prayer. What is the second? What is the second prayer, guys? Omwenga?
I'm trying.
that the court do grant the applicant an order to enter, search, and seize, sorry. Maybe, let's say it was an AK-47.
Stick to documents.
Okay. That the court do grant the applicant an order to enter, search, and seize the documents in custody of the respondent.
To seize, to enter, sorry, to enter, search, and seize
the documents. Do we need to specify them?
Yes, you can't just go seizing documents. Which document are you looking for? Why are you going to that person's house? Okay, you have to tell the court which specific document are you looking for. So could be title deeds, could be logbooks, could be receipts. Okay. So you could have, or a class of documents. Okay, you could have a class of documents. So it doesn't have to be one. You can have a class 2 documents or one class of documents, and so on and so on and so forth. You get what I'm saying?
Yeah. So I continue.
I'm listening. Yeah.
Okay. Search and seize. Title
what?
deed and seize.
Okay.
Title deed for LR number 204 stroke.
All right. Search and seize. Certificates of title.
LR.
Well,
LR 204. Kajiado, yeah.
Which document? Maybe there are many. So LR that. You could have another. Maybe payment receipts. Payment receipts dated maybe 23rd, or payment receipts between, or sort of dated between 2nd September 2024 to 31st September 2024. So guys, this doesn't mean that these are the documents that you're going to have. Okay, it doesn't mean that these are the documents that you're going to have. You could have a lot of documents or just one. Depends on what the examiner is telling you. So don't create your own document. The question will have the document. So just look at the question and look at what documents is this person seeking to seize. Okay, that is what we are simply saying. So the documents will be the question. You don't have to stress about the document. They will be in the question. But what will not be in the question is the prayer. So the prayer is that the court do issue an order or grant an order of enter, search, and seize, to seize what documents or what items. They could be books, okay? They could be cards. So whatever is in that house that needs to be picked. There could be items, not just documents, okay? They could be laptops. They could be phones, okay? Computers. There could be pens. Anything that is in that house that is relevant to the case, okay? Are we together?
Yes, Mwalimu.
Yeah, Mwalimu, we're together.
Okay. Are we together?
Yes, Mwalimu.
All right. So, from the respondents, office located at XXX, or respondent's home, respondent's office, respondent's shop. So you'll be told where the documents are. So you have to say again, where are you going to enter? That must also be very clear. Again, that will be the question. So Anton Pillar is an instance where, and I'll get you a question on Anton Pillar so that we can all discuss it. We can all discuss it and you understand what Anton Pillar really is. Okay, so like I've said, this is an instance where you are trying to get an order. You are trying to get an order to enter, search, and to seize. Okay, enter, search, and seize something that is within the custody of the defendant or the plaintiff. It doesn't matter who, custody of the defendant or the plaintiff. Are you together? So in that instance, you pray for an order of Anton Pillar. Anton Pillar. It comes from the Anton Pillar case. Okay. Why do we call it Anton Pillar? Because it is that case that gave rise to the Anton Pillar orders. The same way Mareva came from that. The same way Jela Kasman also gave us the temporary injunction. Okay. But also Jela Kasman will be applicable in this instance. Jela Kasman will be applicable in all instances of any injunction. If you forget Jela Kasman Brown, we have a lot of cases. We have Marao Limited versus First American Bank. We have Uhuru Highway Developers versus Central Bank of Kenya. We have the Ethicon Limited. We have a lot of cases dealing with injunction. So you only need to know the case when you are preparing a ruling, or you are preparing an opinion, or you are preparing submissions. But all in all, still, you can prepare all that without mentioning a case, but at least have a case. When it comes to injunctions, you know Jela versus Kasman Brown is the locus classicus case. Any person marking your work will be expecting that you know Jela versus Kasman. Are you together? So some things will just come. You don't have to quote 10 cases, but at least the locus case should be clear, okay? Like Jela Kasman and Mareva case. Okay, so let us go back to I'll take questions in a minute. Let us go back to our questions. So remember, this is an application. So again, the examiner will be marking from the caption, who are the parties? Number 2, applicant, respondent. Do you capture them well? You have to indicate who is the applicant and who is the respondent. Okay. Notice of motion. Which rule are you coming under? Are you coming under 38 or are you coming under 39? Are you coming under 40? Are you coming under what is the rule you are coming under? Now, I have said again and again that anytime you're not sure about the rules you're coming under, you're allowed to quote the overall the general provisions, which is Order 51 of the Civil Procedure Rules, Section 1A, 1B, and 3A of the Civil Procedure Act, as well as Article 159 of the Constitution and all other enabling provisions. Okay, that is that. And we have always said all the time that a notice of motion will just be introduced in the same manner. Are you together? So provide a take notice that this honorable court shall be moved on the dash day of dash 2022. Normally, don't write the date here. Let me just remove it for you. Don't write the date here. Okay, because it is the examiners, no, sorry, it's the people at the registry that will be fixing the date. They will tell you when. Once you're given a date at the registry, that is when you will know when the court will be moved. Okay, so normally when you prepare it under certificate of urgency, then you have to leave it upon. Normally what happens in practice, all certificates are had at 2 p.m. You file it today, so long as you file it before 12, it will be heard the same day, 12 or 2. Sorry, 2. Of course, some courts will delay, but the practice is that anything that is brought under certificate of urgency must be dispensed with within the same day because it is urgent. So it will be heard the same day. Okay, but you don't include that date. You just leave it blank, and the person that is preparing the course list, that is the clerk, will insert a date there. The clerk will insert a date there. Okay. Now, after that, nothing changes. You just go to your prayers, which you have indicated. You pray for cost, and then you go to your grounds. So what are the grounds? The grounds, for instance, you are saying that the applicant, that the respondent has been hiding or as depends on what the examiner wants you to understand or wants you to say. You know, when it comes to grounds, you pick exactly from the question. You could be told that the respondent has been printing. Okay, the respondent is printing the books in his house. So you need to go and search and seize those books. So whatever the question says, okay, whatever the question says, printing the applicants books from his house without any license or authorization. Okay, so essentially what I'm saying is that you will have grounds from the question, which will be different from fact to fact. What will not be different is the fact that it is Anton Pillar, and therefore you pray for an order of Anton Pillar through a notice of motion supporting affidavit. And of course, you know, once you prepare your notice of motion and you date it, then you prepare your supporting affidavit by simply indicating caption as per the notice of motion above. And we have discussed that a lot of times. So this is what I'm saying. So you will come here and say caption as per the notice of motion above. So what does this mean? This means that you don't have to repeat the parties, Republic of Kenya, the parties, you don't have to repeat them. Let me bring it up. So once you do that, it just comes straight and write supporting affidavit. Supporting affidavit. Okay? And then you come and say the applicant in our case is Wakoboru. Wakoboru is my friend. I told you. Wakoboru of your box that Nairobi do make oath and state as follows. Okay, do make oath and state as follows. So what are you stating? The first one, that I am the applicant in this matter, hence competent to swear this affidavit. Okay. Number two, now you go to the real things now. You start copy pasting. Once you write that, you start copy pasting. What are you copy pasting from? Just go back to the question and give us what happened. That the applicant discovered that the respondent was printing, and publishing his copyrighted books. Of course, the examiner will give you the title of the book. All that will be in the question. So guys, whatever I'm writing here, I'm not getting it from my head. I'm just trying to see a question. Okay, so it will all be in the question. So don't worry when you get there. Okay, books without any license. Okay, full stop. Blah 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 blah, and then you come here and say that once you give the whole narration, then you are going to, for instance, so assuming, I'll come back to that. Let me just let me complete the statement. That is the last statement of your supporting affidavit, that what is stated herein is true, the best of my knowledge, information, and belief. Okay, full stop. You go back there and say, sworn at Nairobi, this dash day of dash 2024. Okay, by, they said, if you don't know how to prepare an affidavit, this is how it looks like. By they said, Wako Boru, before me, Commissioner for Oaths, drawn and filed by, reserved upon. Okay, this is an entire affidavit. This is an entire affidavit that we've drafted right there. So you just bring your story. Once you're done with the story, sworn at Nairobi, and of course there must be a place for signing for the applicant, the person that is swearing the affidavit. Is true, not try. Is true to the best of my knowledge, information, and belief. All right, guys, are we together on affidavits? So assuming that you captured, okay, you captured this person, or you found a copy of the said book in the market. Because remember, when you're doing your affidavit, the role of an affidavit is to support. That's why it is called a supporting affidavit. The role of an affidavit is to support. So how do you support? You support by facts and you support by evidence. Support by facts and by evidence. Now, the first way is you give the facts. Okay? Give the facts. Give facts. That is the first way. Give us the facts. And then the second way, give us evidence if you have evidence. Give us evidence if you have evidence. What is the meaning of you giving us evidence if you have evidence? What I'm saying is this. If you have evidence, we are simply saying there's the question telling you that some documents, for instance, how did you know that he's printing the books at his office? Maybe you found a copy of the said books that have been printed And at the back, they have an address of where they were printed from, which is the defendant's premises. Okay? So you will be suing the defendant. Remember, guys, you will be suing the defendant for breach of your IP, breach of your copyrights through a plaint. But that plaint will be accompanied by an application for Anton Pillar. So, assuming that you got the book, right there, assuming that you have evidence that there's a book that has been printed from that location or has been printed by the defendant, but it is your book. So you adduce it as evidence. So you'll be saying, okay, attached herewith, because you have to attach to the affidavit. You have to attach all the evidence you're adducing, you attach to the affidavit herewith and marked. Okay, so exhibits are marked. So I don't think whether we have spoken about this, but I'm talking about it right now in terms of how you prepare affidavits. Now, affidavits are supposed to produce two things, okay? Facts, which is the story, the entire T in the question. Facts, you give us the facts as they are, okay? Two is evidence, so that if you're saying that I am there, or assuming that this was a company, and you're saying that I've been duly authorized by the company to swear this affidavit on their behalf. You have to produce evidence of that, which is attached herewith and marked WB1 is a copy of the letter of authorization. Okay, so you have to produce evidence. Evidence or documents produced before the court. There are ways of producing documents in court. The first way of producing evidence in court is through actual testimony, physical testimony. You go to court and your question in court, and you answer questions and you produce a document. The second way is affidavit. You produce documents by way of affidavit. So how do you produce a document by way of affidavit? You are simply indicating, for instance, in this case, that this person is printing your books from his address. How do you know that? Because you found a copy of that book on the shelves, okay? Which indicates that it has been printed from such a location. So how do you produce that book as evidence in your application? You attach it and you mark it. So marking simply means when the court is perusing, remember, you're going to have a record or a list of documents and a record of documents, okay? You're going to have documents right together. So your supporting affidavit will be having documents attached to it. So as the court is looking, the court will come and say, attached herewith and marked WB1. So where is WB coming from? The name of the applicant. You just take the initials of the applicant's name and they become the marking. So if the applicant is called, let's say, Alfred Adrian, so your marking will be AA. If your name is Abdisalan Gure, your marking will be AG. Okay, so when you come here, you are saying attach here with and marked WB1. It means Wakoboru 1. WB1 is a copy. Sorry. A copy or is a sample. It's a sample of the book. Okay, so if the court is reading, the court will just open WB1 and they will find a sample of the book. Okay, a sample of the book. For instance, let's assume this is paragraph 3 is not related to books. I'm still explaining a point. Paragraph 3 is not related to books. Okay, so let's assume here. Let's assume that you are saying that you bought the property. Sorry, you are saying that is a property that you bought. Okay, for instance, you'll be saying that what is happening here? Because it is you applying, I mean, it is you making the application, you are speaking in the personal tense. So I, the first pronouns. So that I bought the piece of land, okay, from the respondent in or sorry on the 23rd May 2024. So what is the evidence of that land that you bought? You'll be saying into brackets, okay, attached herewith. Somebody tell me, what should I write? Attached herewith.
Sale agreement.
Wewe,
Attached here with unmarked. Attached here with
also. Mute microphone. Wewe is saying that. Shetani akulambe uso. What do you mean sale agreement? Guys, mnataka kiboko. Attached herewith and marked what? Let's mark it fast.
WB2.
Yes, WB2, because we already have WB1. WB2 is what?
A copy of.
You guys are crazy. Top class
a copy
crazy.
Of title deed. Copy of a title deed.
It's a copy of
the title deed.
The certificate of. There's nothing like a title deed. A title deed is a pedestrian language. Speak like a conveyancing lawyer.
Certificate of title.
Thank you very much. The certificate of title. Okay. So if the examiner, so not the examiner, if the court is perusing the document, you will just go to WB2 to see the title. So you can't bring them. You can't say that, okay, I'll bring my title, I'll bring my logbook, I'll bring this and this and bundle them together. No, there must be order. So you attach them so that if I'm reading your application, okay, I've read your application, now I'm in your affidavit. I'm going to paragraph 2, okay, that the applicant discovered that the respondent was printing and publishing his copyrighted books without any license, okay? And then I will see you've produced evidence attached herewith and marked WB1 is a sample of that book. So I will stop there as the court and I will go to the bundle of documents and I will peruse the documents and I'll go to WB1 because even in the documents, you will mark them. Okay, there's a stamp for marking documents. You will stamp there and write WB1. You go to the next document, WB2. So for me, I'll just go to WB1 and I'll see, okay, this is the document. Okay, I'll keep reading that I bought the piece of land from the respondent on the 23rd May 2024. Attached herewith and marked WB2 is a copy of the certificate of title. So if I want to see the certificate of title, I will peruse to WB2. So it is the easiest way to adduce. This is how you adduce evidence. Guys, I've said, don't be crazy. I know some of you will be crazy in the exam. You will be producing your own document. Don't create documents that are not being told. You're not being told. If the examiner does not mention certificate of title or anything, don't create it. Just give us the facts. Like I've said, guys, evidence could be facts and documents. So if there's a document to be produced, produce it. How do you produce it? 2 ways. You attach and you mark. Attached herewith or attached herein and marked WB1. And that W doesn't have to, don't go to an exam and now write WB. No, you look at the name of the applicant. The name of the applicant. So the name of the applicant, the initials of the applicant will become the marking system. But if you're not given the name of the applicant, which will be rare, you can use any word. So long as it is consistent, you can say A1, A2, A3, A4, C1, C2, C3, evo. But normally the initials of the applicant will be the marking scheme. So WB1, WB2, WB3. That is how you adduce evidence. So as you prepare your supporting affidavit for all your applications, guys, as you prepare your supporting affidavits for all the applications, make sure that you are not only producing facts, but also documents if you are told. Okay? If there's If there's something like a copy of a judgment, produce it. Say attached here with is a copy of the said judgment. Guys, tunaelewana? Am I making any sense?
Yeah, you're making sense.
All right, so this is how you prepare your supporting affidavit. So don't go and start saying Republic of Kenya. You can do that if you're fast enough. If you're fast enough. Okay? If you're fast enough, you can mess around and have draft everything back again, all the caption again, say, oh, Republic of Kenya, parties again. You can do that if you want. Nobody will beat you. But remember that time in civil, time is money. Time is money. And time is very rare. Very, very rare. Those questions are too much. So if you can't maintain time, keep time, you are going to fall in trouble and you're going to cry later as you board that ugly bus from Karen to maybe wherever you're headed to. It will be tears for you. There's nothing sad as knowing the answer, but not getting the time to write that answer. You will cry. Paka kamulu. Okay? So, please, I tell people, when you go to that exam, don't waste time, guys. Don't waste time. 90% of people that fail civil is because of time. Even people that are in this class that are reciting this paper, you ask them, it's not about that they didn't know. They knew the answer, but they didn't have time. Time is usually a serious problem. And that is why don't waste time trying to decorate. Some of you will be even drawing there the commissioner's stamp. They're trying to make it look nice. My friend, you shall know. So that is how you produce documents and go straight to the point. Like you saw in the question, okay? Let me show you something. The one that we did in the last class. The question that we did in the last class, 2021 June question 1, okay? We did that question in the last class. I'm still having it open. Let me open it quickly. The grounds and your supporting affidavit can be 2 lines only. Okay? You see here. I don't know whether you're seeing what I'm projecting. This is question 1. You see how it is short? Okay? You see how it is short?
Yes.
This, whatever I've highlighted, that is what will go to your grounds and that will go to your affidavit. Those 2 lines that I've highlighted, those are the only things that will go there because that is the relevant facts. Okay? That is all the examiner has given you. So don't be creative and try and create other things. No, just stick to what the grounds will come from the question, affidavit will come from the question. So if the question is as short as the one that I'm showing you, don't create facts, okay? Do not create facts. All right, that is all about Anton Pila. Guys, like I've said, you will not understand it now, but the first thing I want you to do before you even draft it on your own, go and read about Anton Pillars. What is Anton Pillars? Some of you in this class do not understand Anton Pillars in terms of what they are or the difference between Anton Pillar and Mareva. So it is okay not to know right now. But like I've said, before you draft anything, know what you're drafting. If it is about striking out of pleadings, don't draft it fast. Go and read about striking out of pleadings. What is it? Why do we apply for it? When do we apply for it? What are the grounds? Okay, what are the grounds? And then you come and draft it by the prayer, which is the main application, the name of the application, the grounds that you've learned. If it is Mareva, what is Mareva? When do we apply for Mareva? How do we apply for it? And the grounds, like we did in the last class until we drafted each of them. Arrest for judgment, same. Temporary injunction, what it is, when. So guys, that is what I'm saying. The next thing is orders of commission, unless somebody has a question. Orders of commission, that is our next application. All right, so 2 questions only, Osman and Musioka. Osman.
Yes, Malimo, my question relates to the Anton Pila orders, where I have seen circumstances in which maybe just before the notice of motion, there are people who write maybe it's an ex parte on top of notice of motion. Is it relevant?
It is not, but we can. It is not. It is not, but I would not advise. I would not advise that you write it because you might mess. Is it, guys? There's a danger. There's a danger in answering or being extra. If you are extra, you better make sure that you're saying the right thing. Okay? If you spell that ex parte, wrong, you're going to get a wrong there just by saying something extra, which is wrong. Okay? So just say notice of motion. Just say notice of motion. Ex parte notice of motion. The fact that you're bringing it under certificate means it is ex parte. The fact that it is under certificate is ex parte enough. So don't come and say, oh, ex parte, and then you spell it wrongly. You get an entire wrong, and you'll be wondering, why did I get it wrong? Because you are extra, and then something went wrong. So if you can write ex parte well, okay, you'll not get any marks though. There's no marks you'll get for writing that. But if you write it wrong, you'll have it wrong. All right.
Yes, that's noted. My other question will be on maybe, for example, the applicant in that order is an institution, and the person who is seeking for the orders on behalf of the institution is an individual. For example, I say, Mr. Ahmed Osman, being an investigator with this entity, hereby seek for to search and seize this and this and this and this in the premise of so and so located here. So is it necessary to mention the name of the person who is executing the order? And also on the part of the respondent may be an institution.
Wait, you're asking a lot of questions. You're losing me. So you are saying which one is the institution? You've said institution. You've said Ahmed. Which one is the institution? Let me bring it back again on the screen.
For example, Ahmed is acting on behalf of an institution or executing on behalf of.
Which is so look at the screen. We have the applicant and the respondent. Tell me which one is the institution.
I'm not referring to this one. Maybe, for example, it is the Directorate of Criminal Investigation is the applicant. And the other is the county government of Narok, for example. The respondent is county government of Narok.
That can't happen. Why can't it happen? Somebody explain to me quickly. I'm going to explain to you why it can't happen, but I want somebody to tell me. Somebody impress me. There's a free class for that. Why can't that happen? Why can't you apply for Anton Pila in respect to the county government of Bomet, for instance, Bishar?
Mwalimu, in my understanding, this is the Bomet is the county government of Bomet is actually one state of the government that we have. Actually, there is a national government and county government. So that's the state organization which you cannot go and search. It's not a private entity or a person.
All right, I will still give you the free class, but yes, just that. So the point is you cannot impound government documents. You cannot get the government documents. When the documents are for the government, you can't apply for Anton Pila against the government. Order 14. I mentioned that sometime when you're starting. So you cannot, there's certain orders. We look at Order 29. When you look at Order 29 of the Civil Procedure Rules, you realize that certain orders you can't get against the government. If the government is the respondent, there are certain orders you can't get. For instance, we said you cannot get Order 14, of course, but let's not start from 14. Let us just start from Order 10. You cannot get Order 10 without leave. That is number one. So Order 10 is default judgment. You can't get default judgment against the government without leave of court. Number two is Order 14. Government documents. You cannot seize government documents. Okay, national policy and security. That is what they say. So national policy, you cannot seize government documents. You cannot go to State House right now and take documents there. You cannot go to the Ministry of Lands and take documents there. No, you are not allowed. So you cannot impound government documents. Okay, that is order 14. Order 21. Okay, order 21. Order 22. You cannot execute against the government. You cannot execute a decree against the government under order 22. That is the ways provided for under order 22. That is execution of decrees. You cannot attach government's property. You cannot send government to civil jail. You cannot
get an injunction. An injunction.
You cannot, not injunction, I'm talking about execution of decrees, attachment and sale of movable properties, attachment and sale of immovable properties, attachment of salary, all that. You cannot impound the government's, documents under 14, order 22. You cannot get orders of execution against the government under order 22. Order 23, garnishee proceedings. You cannot have an order of garnishee against the government. And you saw Justice, who is this judge, the new judge? The new judge called
Sifuna.
Yes, thank you, Sifuna. You saw Sifuna trying to mess with that, and the Court of Appeal said no, sit down. Okay, the Court of Appeal said no, you can't. Certain orders you can't. The government is protected, so you can't. So that is order 23. Garnishee proceedings you can't get against the government. Order 40, you can't get before order 40. Order 36, you can't get order 36 against the government. That is summary judgment without leave of court. Okay. Again, order 40, injunctions, you can't get injunctions against the government. You can't get injunctions against the government. The best you can do is get a conservatory order. So yes, you cannot have Anton Pila against the documents of the government. Will not happen. So guys, so Ahmed, I think I've answered you. You cannot have. But if it was a company, if XYZ, the respondent was a company, you can go to a company and get the documents from the company. If it's a company, not a government institution. Because how?
Sawa mwalimu.
All right, sawa. So let us go to orders of commission. Orders of commission are provided for under order 28. Order 28 provides for orders of commission. So again, the same test that we've been using all the time. What is an order of commission? Okay. When or why do we get an order of commission? And then 3 is how do we get an order of commission? And then of course, the grounds, which of course will be informed of when and how, when and why. Okay, so that is orders of. So guys, once you understand this question, this general question that I keep asking all the time in every application, what it is, when you get it, how you get it, and the grounds. So once you understand what it is, okay, you'll be able to get from the what, you get the prayers. From the when, you get the grounds. Okay, and then from the how, you get your notice of motion. So that is what I'm saying. And that's why I keep saying and I keep singing that fast people go and read these things. And then once you've read, then you can come back and draft. Okay. There's an outbreak. I don't know whether it is a sickness or something where people are so interested in drafting. You know, most of when you're in KSL and you're almost going to exams, you always want to draft, you know. Ukisikia place watu na draft, unataka kwenda huko. Sema, oh, let us go draft. I'm drafting. You don't realize that you cannot draft what you don't know. Okay? You can't draft what you don't know. So please, do not rush. I'm not saying drafting is bad. I'm just saying drafting will be 100% easier if you know what you're drafting. Because as you've seen, guys, the same notice of motion that I've been projecting is the same one that I've been projecting. Every application will not come with this, or is the same notice of motion. So if you knew what you're praying for, if it is orders of commission, just put prayers there and grounds. Full stop. Mareva, prayers and grounds. Same notice of motion will have the same thing. So don't worry about drafting a notice of motion. Worry about knowing what is an order of commission, when do I get an order of commission? How do I get it? And the grounds. Because sometimes I've explained this, the examiner is not interested in you drafting. The examiner will be telling you, advise this person, give them an opinion, or write a ruling. And the ruling is on orders of commission. If you are only fixated in terms of drafting, you will not draft a ruling because you do not know what it is, when it is, and how it is. So focus on that. Once you know what the question is asking, which is an order of Anton Pillar, then your mind will wire very quickly and you'll know my prayers, this and this and this, my grounds from the question, this and this. And then you get done. If it is write a ruling, you'll be writing a ruling, the facts in the question, the issues, whether the application for Anton Pillar order is merited or whether the application is merited. And then you go to the analysis, the rule of law. So you provide what needs to be shown when somebody is applying for Anton Pillar, which of course I've said the Anton Pillar case as well as Jela versus Casman Brown. Okay, that says the court shall grant an order of Anton Pillar or injunction in the instance where there is a prima facie case and all that. So you get what I'm trying to say. I'm just trying to insist that as well as, I mean, it's as much as yes, you are trying to draft, but please know what you're drafting. Drafting alone will not help you. In that exam, probably you're going to draft just one or two things, but most of them will be prepare an opinion, write submission, okay, write a ruling, advise, direct. Okay, so please focus on understanding the point. If you are able to explain to a layperson what Anton Pillar is, then yes, you can draft it. So if you still can't, then you can't draft it. Then don't worry about drafting. Focus on knowing what it is, which I've already explained. Now, orders of commission, commissioning, to commission, commissioner, okay, commissioner. You guys have been commissioners before. Some of you are commissioners, you know. Some of you are directors, you know. Some women call their husbands commissioners. If you are here and you're being called Mr. Commissioner, hey, syllabus imeenda sana. Syllabus inakimbia sana. Kama wewe ni commissioner, you know what a commissioner is. Okay? So what is an order of commission under Order 28? Okay, what is an order of commission under Order 28? Now, this is an order of direction. Let me just start from that. This is an order of direction. And what do I mean by direction? What do I mean by it being an order of direction? I mean, why is this not moving? All right, but I hope you can see it. It's not moving, but I hope you can see it. So what I mean is this. Sometimes there's certain things that needs to be done. Okay. Now, orders of commission relates to, number one, examination of witnesses. Number two, it relates to examination of accounts. Number three, it relates to a local inquiry. Okay, a local inquiry. Those are the three things mainly that you will be doing orders. I mean, you'll be commissioning. Okay, so let us start with examination of witnesses. Okay, number two, who is a commissioner? A commissioner can be a magistrate, the deputy registrar of the court, or an advocate of the High Court of Kenya, or any person that the court may direct. Now, orders of commission are orders that are given directing a person to go and examine a witness, to go and examine accounts, to go and conduct a local inquiry. Okay, let us start with the examination of witnesses. Now, within the Act, that is the Civil Procedure Act, there are certain people that are exempted from attending court. Okay, because of infirmity, or because of sickness. They are sick that they can't attend court. Okay? So because they can't attend court or because of the sickness that they're having that cannot make them walk to court, the law allows them to just be there. But if we want their evidence, we will send someone to them. That person we are sending to them is called a commissioner, to go and commission them. Guys, you know commissioners of oath. When you're commissioning an oath, it means you are going to the commissioner and the commissioner is commissioning you. Okay? Taking your statement is commissioning you, taking your statement under oath. I don't know whether tunaelewana. Sijui kama tunaelewana, lakini let me try again. Okay? Now, you know commissioners of oath. Okay? Now, in certain documents, you will need an affidavit. An affidavit can only be taken by a commissioner of oath. Okay? Now, when you go to the commissioner, you are giving the commissioner a statement under oath. And that statement is deemed to be serious. It is deemed to be very, very serious. And it has a very high probable value because it is sworn. It's like you are swearing. I swear to God. So that I swear to God, you go and swear to the advocate, which is the commissioner, and that becomes an affidavit. So the person that is asking you questions or taking your statement, remember, the person is taking your statement under oath. So yeye ako tu hapo. Now this is what is deemed. Okay, guys, this is what is usually what is intended to be happening. What the law thinks is happening when you go to make an affidavit. That you walk to an advocate's office, you sit down, they give you the Bible and you carry. Okay, you carry the Bible and you say, I swear to say the truth, nothing but the truth. And then you write down your statement, and then the advocate will sign and say whatever has been sworn here is what exactly you say. But that doesn't happen. Of course, practically it doesn't happen like that. But the reason why we are sending it to that person is because you need to make a statement under oath. The same way, if you are in court, you'll make a statement under oath. How do you be under oath? You carry the Bible and you say. So that is essentially all the things about commissioning. But let's come back to this one. Now, at any time, at any specific time where you are not able to attend court, we shall send someone to you to take a statement. Okay? Now that statement, it is not just a lazy statement like anybody can take it. No, it must be taken by a commissioner. Somebody who is going to commission you, a commissioner. It is taken under oath because you are not in court, so the court can ask you direct questions. We will send someone to you. Okay? If you are sick, we shall send the pastor to you, and the pastor will, ordained pastor, will not send the pianist or the choir leader to you. We'll send either the church elder, the bishop, or someone who is ordained to come and pray with you. Okay? Are you together? That is the same thing. When you are out of court and you can't come, we will not send anyone to you like, okay, so the court clerk, go and see that person and take their statement. No, we can only send someone who has been ordained to take a statement, and that person is called a commissioner. Okay, so when they come to you, they take your statement, and that statement that they have taken is deemed to have been taken under oath. Then they bring it back. Okay, so that is the first thing. So we will send send the person to you. The person is called a commissioner. Okay, so what do I do if my witness is not able to attend court? I make an application for an order of commission for the examination of XYZ who is sick. Okay, so the court will appoint a commissioner, and the commissioner can be a magistrate a magistrate within the jurisdiction. So if you are within Nairobi, the High Court in Nairobi, can issue an order to the magistrate in Nairobi to go and do the commission, or the DR go and do the commission, or an advocate who is a commissioner of oath go and do the commission. So they will come to you, they will ask you the question, and then they will bring the statement back to court, and that will form part of evidence, as if you yourself, you are in court. So we bring the court to you instead of you coming to court, and that court is the commissioner. Okay, that is examination of witnesses. Now, in the instance, I think there's a question that is set like that in 2022. I'm not very sure, but I'll check if there's a 2022 question on commissioning. There's one, but you could be told, for instance, there is COVID lockdown. The witness is in Mombasa, so could be sickness, or they are in jail. They can't come out, and it will be impossible for us to get that person from jail to come to court, or they are very, very far from court. They are in Mombasa and the court is in Kitale or Busia. Okay, so we can't get them, or they are children and they are in school. We don't want to interfere with their schooling, so we send someone to them. So guys, there are a lot of instances that can make someone not be able to attend court. And when somebody is not able to attend court, we send a commissioner to them. And then the commissioner will examine them as if they were in court, and then record that statement and bring it to court. That is orders of commission. Number 2 is examination of accounts. Okay? If there's a problem with the company's account, for instance, or a bank account, or some institution's account, or a personal account, the court can send someone to go and inspect those accounts. That you go to the bank, inspect those accounts, go to the company, the same way we have auditors. Go to the company, the commissioner is the auditor, is the court's auditor. Go to the company, look at the books of account. How much money has this company been making, and what have they done with the money? Okay, what have they done with the money? That becomes an order of commission for examination of accounts. Or conduct a local inquiry. Conduct a local inquiry. For instance, the residents of Rongai have complained that everything is not constant in Rongai except dust. So the court will want to know, what is the problem of this dust in Rongai? So the court will send a commissioner in Rongai to go and conduct a local inquiry. What is happening down there? Okay, why is everyone coming to town? Pupils reporting to their offices in town with their heads gray or brown. What is wrong? So the court will send someone down there to conduct a local inquiry. So it is only that inquiry is not done suo motu, guys. The inquiry is not done suo motu. It is only done if it is subject or relevant to the suit. Okay. For instance, if residents are complaining, okay, if residents are complaining that Quiver, some of you sleep and work from Quiver, kuingia ni 5, kutoka ni 8 am. Ama bouncer wote wanaenda wanakuacha tu hapo, wewe bado uko tu hapo, and you don't think something is wrong with you. So residents are complaining. They have sued Quiver. They're saying, Quiver, you are making noise. Okay, you are making noise. We don't want to hear noise. And Quiver is saying, no, we are not making noise. We're not making noise. I mean, our sound levels are very low. So what will the court do? The court will send a commissioner. That you, commissioner, go there to Quiver and see whether that noise is high, whether it is creating disturbance. So the commissioner will go and conduct an inquiry into this noise. Okay? Or there's a question, there's something wrong with some titles, the boundaries. The court will send a commissioner, go and do an inquiry on those boundaries. What is wrong? Why are people in court? And then you bring a report. Another instance you've seen during the presidential election petitions, okay? The court ordering that go and open the server. Open the server. So the court is giving an order of commission that the server be opened and a report be filed. That is an order of commission to conduct an inquiry. okay, when you open the server, okay, you conduct a local, those are orders. So guys, that is an order of commission. That is the context of an order of commission. So examine a witness, conduct or inspect accounts or examine accounts, or conduct a local inquiry. So how do you do that? You make an application to court, notice of motion, and a supporting affidavit. What are you praying for? Guys, the name of the application is the prayer, okay? That the court do issue an order of commission. For what? For what? Or the court do appoint a commissioner to do what? To examine person XYZ, okay? To examine person XYZ, okay? And then cost. And then in your grounds, you will tell us why person XYZ should be examined, okay? For instance, that person XYZ is sick and currently admitted at the hospital and cannot walk, or is in the ICU and cannot walk to court, or is a child that is in school, or there is COVID lockdown, so you can't go to Mombasa. So you give an order to an advocate in Mombasa or a magistrate in Mombasa to conduct that local inquiry and send that statement to court. Okay, because you can't move from the borders. The government has locked down the country. So guys, just pray for an order of commission to do what? Tell us what you want to do. To conduct a local inquiry, to examine, or to examine accounts. Okay, and then you go to your supporting affidavit. Okay, supporting affidavit. You'll be saying, I, person XYZ of PO Box this and this, do make oath and state as follows: that I am the applicant in this matter and therefore competent to swear this affidavit. Okay, that, remember, who do you want to examine? Person XYZ. That person XYZ has been admitted in the hospital and is not able to move. Okay, evidence attached herewith and marked. Okay, if you are Alosi Samora and marked AS1 is a copy of the admission letter from the hospital or admission letter. Okay, full stop. And you proceed just like the question. Guys, these things are very easy. I don't know whether I'm biased, but I think these are things that if you take time, slowly by slowly, you will realize they're very easy things. Okay, that is an order of commission. Na hivyo ndo tumemaliza. So what happens after you conduct an inquiry? You conduct an inquiry, you compile a report, that report is brought to court and it becomes part of evidence of the file. I mean, in the file. Tunaelewana, guys?
Yeah, so.
All right, so that is orders of commission, and also it deals with people that are in custody, people that are in that are at war. If you are a military person, if you are not in Kenya, again, sorry, I forgot to mention that if you are out of Kenya, or you are literally not able to come. Okay, so that is making sense. And I've said you can also examine out of Kenya. So that is orders of commission, guys. That is orders of commission. Once you do the commission, you return the commission. You return the commission. So if you want the court to do something, you do that. So that is under order 28. Please look at order 28. If you're starting to read order 28. Okay, read order 28. If you're starting to read order 28, just to understand orders of commission. So what I'm projecting is proceedings by or against the government. Order 29, like I've said, certain orders do not apply to the government. Certain orders do not apply to the government. Serikali ni serikali. Which set book said that? Free class. Serikali ni serikali. Let me see. Wenye walikuwa wanasoma high school, wengine walikuwa wanaenda funky kila siku funky na long year first year form 1. Serikali ni serikali. Tatua dondo. Ilikuwa what dondo, whatever. I don't know those things. Which set book was saying that? There's a free class for that as well. Yes, mstahiki meya. Gloria, you have a free class. Serikali kweli ni serikali. Yeah, so that is that. That is that. Kuna wenye hawajui set books. Walipita tu high school bila kusoma set book, wanashangaa hata walipita aje. Hata wanashangaa hii set book ni gani.
Watu walipita.
Kuna wenye mpita mpaka wanashangaa hajamini mpaka leo wanasema we? Huyu si mimi. Huyu si mimi nilipita high school. Set book hata jui ni gani. Ni nini kwanza mnaongelea hiyo set book? But tunashukuru Mungu. Tunasema thank you God. Okay? So guys, like I said, I already mentioned this, that these orders are not available against the government. No order against the government may be made under Order 14, impounding of documents. You cannot impound government documents. Order 22, execution of decrees. Order 23, attachment of debt, that is garnishing, injunctions, and of course, appointment of receivers. You cannot appoint a receiver to receive the government's money. You will not receive anything. Okay? So that application cannot go anywhere. Order 10 and Order 36, you cannot do that without leave of court. All right, so next one is the question of discovery. Swali. Kama kuna mtu kuna swali, aswalishe. Put up your hand and tell me if you have a question. If there's no question, we can go and talk about discovery. All right, so let's talk about discovery. Guys, are we together up to, because discovery is our last interlocutory application, but I've said we could have more applications. We'll do more as we go, but for now, these are the ones that we want to address up to there. That is what is in the course outline. Are you together?
Yes, Mwalimu, we are together.
Okay. All right, so let's talk about discovery. Okay, let's talk about discovery. What is discovery? Okay, what is discovery? Defendant. Let me just write that defendant there. And then tap copy, paste. Discovery. So guys, what is discovery? So again, discovery will come in this instance. Okay, discovery will come in this instance. I have sued Bishar, for instance. I have sued Bishar. Okay, I have sued Bishar. Now, in the course of suing Bishar or after suing Bishar, the suit is proceeding. I feel like there are certain documents I want to get. There are certain documents that I think Bishar has that I want. Okay, I want more information. I want more tea. Okay, I want more tea, more information. Or Bishar has sued me, for instance. Bishar has sued me. I'm the defendant. Okay, so I've responded, but I want more. Okay, I want more information. So that is discovery. I need to discover. So if you want more information, it means you are discovering. I am discovering. Okay, so you need to go and discover more. So how do you discover more? There are two things you can discover. The first one is a discovery of documents. It means I want some documents. Bishar has mentioned that there's some documents that he has. For instance, he has said that the accident happened. Okay, the accident happened, and then I incurred or I used 10,000 shillings as treatment or as a police abstract. I will be telling Bishar, letter nini, receipts. That is me discovering documents. So if I want documents from the other party, that is a discovery of documents. Discovery of documents is called inspection. Okay, it is called inspection. A discovery of documents is called inspection. So inspection. So you are inspecting. You're telling them, hey Bishar, please give me the following documents for my inspection. I want to inspect them. You're saying that ulitumia 10,000. Umelipa Uber 10,000 from Thika Road to Rongai. Later receipt up. Okay, so you want to discover more. You're discovering documents. So inspection, you inspect. Number two, you can go and discover facts. It means, for instance, Bishar is saying that an accident happened and then I injured my leg and then he ends there. For me as the defendant, I want to know more. Which accident happened? Who was involved? Where was it? When was it? Which hospital treated you? So that is me. I don't want documents. I just want him to tell me more about this accident that he's speaking about. So I'm looking for more facts. So that is discovery of facts. And we call that interrogatories. 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 Now, interrogatories, you know what interrogatories are? From the word interrogation. Interrogation. When somebody is interrogating you, they're asking you questions and you're answering. They're getting facts from you. It is called interrogation. Interrogatories. So interrogatories, if you meet the word interrogatories, don't think that now your village elders are wanakuroga. It is just interrogatories, like interrogations. Okay, it is a very simple thing. When you want more facts from a person, you interrogate them. Okay, you interrogate them. So how do you interrogate? You ask the question and they answer. So interrogatories. So if you're told to prepare interrogatories, again, that is you preparing questions that you want answers for. Simple sana. So in question of discovery, I've said discovery is you getting more facts or more documents. If it is on documents, it is inspection. If it is on more facts, the only way you can get more facts from a person is if you ask them a question and they answer, and which is interrogation, interrogatories. Tuko chonjo? Tuko sawa?
Yeah, sawa.
Perfect. Now, let us go and talk about now the procedure. Okay, the procedure for inspection. We start with inspection. The procedure for inspection. Or should we start with interrogatories? Okay, no, let's start with inspection. There's procedure for inspection. Okay, and then a response. A response. So just note those things down. So if I want to interrogate, to discover documents from Bishar, if I want to, discover documents from Bishar, what do I need to do? I need to send out a notice to produce. Okay, a notice to produce. Are you together? I need to produce. To send out a notice to produce. So I will send to Bishar. Hi Bishar, please take notice that you are hereby required to produce the following documents for the inspection of the plaintiff, for instance. And then I give the list of documents. Once I'm done, dated, drawn and filed by, to be served upon. And then Bishar on his end will proceed and do his things. Okay, he will respond by sending me what you are calling a notice to inspect, telling me, okay, fine, I've received your notice to produce. I am willing to produce the following, come and inspect the following documents. So two documents are involved when it comes to inspection. The first one is called a notice to produce, where you are telling the party that you want to produce documents, you are telling them to produce, tell them to produce. Okay, that is the first one. And then if they're going to produce, then they have to send you a notice to inspect, asking you to come and inspect. Wadau, tuko chonjo. Am I too fast, too slow, maybe?
Yeah, okay, mwalimu.
Good base.
Okay, so notice to produce, notice to inspect. So let us see that in a practical sense. My screen. So these notices are usually sent, of course, if Bishara has an advocate, I've sent it to Bishara's advocate. If he doesn't have an advocate, I will just send it to him. So how do you prepare a notice to produce? It is the easiest thing you'll ever draft in your life. Caption of the case as it is, Republic of Kenya, in the High Court at that, civil case number that, the parties, notice to produce. If you don't remember section 69 and 22 of the CPA, don't write anything under notice to produce. Just say notice to produce. And because there is a notice, it is sent to someone. Notice must be sent to someone. So this is the defendant's advocate. So you send it to the defendant's advocate. Okay, you can send it to anyone. So if the person is appearing on his own, then you send to them. So if Bishar was appearing on his own, I will write here Bishar. Or if it's XYZ, I'll write XYZ there. Okay, that is a very simple thing. Just the caption, the parties, and then to the person you're sending the notice to, and then take notice that you are hereby required to produce the following documents for inspection of the plaintiff. That is all. You list the documents, document number 1, number 2, number 3, number 4, number 5, up to document 14. And then when you're done, dated at this day, at this date, drawn on file by to be served upon. That is all. You're done. So list the documents. So in the question, go to the question and see which documents is your client looking to get. Which documents is your client looking to get? Which documents is your client looking to have? Okay, so once you know them, you prepare a list of them. Okay, prepare a list of them. Guys, tunaelewana?
Mwalimu, could you kindly scroll down just a bit so that we see the rest of the body kindly?
All right, so, but these documents are not relevant in these ones. So it could be anything. It could be anything. Copies of screenshots, copies of the email, title deed, demand letter, all this, all that, treatment notes, payslip, any document that will be mentioned in the question will be there. Okay, so let me do this. Let me do just this. No. Okay, I know some of you, so let me just do this. So I've removed all those documents. So let's draft one. So 1, title deed. Deed number LR 123/65. Demand letter dated 22nd sorry, where am I? 24th July 2024. Copies of email from 3rd September to 20th September 2023. Screenshots. Conversation between you and your wife. Yes, sometimes this will be required. Employment contract. You know, so these are the things you are preparing. Okay, so the question will tell you again, guys, don't be creative. Do not be creative. Okay, do not be whatever. Creative. If you are creative, you will cry. Do not be creative. Okay, just write what the examiner has told you. If you're told demand letter, just write it. Don't create documents for your own. Just write what the question is saying. So that is what you're calling the notice to produce. Okay, so let me just even remove this one. So I'll just write there Bishar, for instance, Bishar. I'm just doing that so that you see that it is not rocket science. Anything can be there. Okay, so that is the notice to produce. Notice to produce. Drawn on file by to be served upon. Full stop. Okay, so let me bring this one up. Let me remove that. All right, so we have that under one document. So if Bishar receives my notice to produce, Bishar will prepare what? I've just said it now. Bishar will prepare what?
Notice to inspect.
Notice to inspect. Okay, notice to inspect. Telling them that Hoya, come and inspect. Kuja, inspect. Are you together? Come and inspect. I don't know if that is clear. I hope it is. All right. Sawa. Now, let us go to the notice of inspection. Okay. So the notice of inspection will have. Let me remove that. Let me have that. And let me remove these as well. Okay. All right. And put that then there. So notice of inspection. So same caption of parties. Now in response, Bishar will write that letter to me back because I'm the advocate that requested the document. So we'll have there. He's now responding to me. Okay. That is how my name is spelled. You know, some of you call me very funny names. I'm not Jacktone. I'm not those funny things you're calling me. Okay. That is a spelling to my name. Please. Kama si Yesu, nimeshika na mkono mbili. Kama si Yesu, nimeshika na mkono mbili. The way you guys are defiling my name thoroughly outside there, would have dealt with it. But anyway, sawa. So that is that. So let me explain something about notice to inspect. Now, if I request 10 documents, remember, I've requested how many? Let's go to the notice to produce. I've requested 5. Now, notice of inspection usually has 2. It doesn't have 2, but it can be divided into 2. It can be 1 or 2. So the first part are the documents that either you are willing to produce or not willing to produce. So tell the person that you've requested for 5. I will not be producing 1, 2, 3. Okay? Number 2, you are able to come and view or inspect 2, 5, and 4, or 4 and 5. So in your response, you must indicate which documents are you willing to give inspection for, and which documents are you not willing to provide inspections for. So for those you are willing, you provide. For those you are not willing, you also indicate. But if you're willing to inspect all of them, that is fine. But most of the time, people will not give you all the documents. They will limit. So here, Bishar will be telling me, okay, here Bishar will be telling me that take notice that the defendant shall allow, sorry, the first one is take notice that the defendant objects to the inspection of the following documents. So from our list, what do you think this person will be objecting to? I'm not saying that is a standard. For instance, you'll be saying, we will not be giving you copies of emails, and then let me just, copies of emails and the screenshots between me and my wife, you know. So Bishar will not want me to see how he's simping down there. So copies of emails, take notice that the defendant objects to the inspection of the following documents. Copies of emails from 3rd to 20th September, maybe you consider them private, as well as screenshot conversation between you and your wife. This could be relevant in the case. Remember that for somebody to ask you the screenshot of your, the screenshot of what you're telling your wife, you know, maybe hata unapigwa na bibi, unabembeleza hapo kwa screenshot, utaki aone. So you refuse, you say hapana, hapo mtakuwa mmeniua. Tough. So usema hapana, hapo hiyo sitoi. Hiyo hata hiyo kesi iende tu. Hiyo kesi hata nipoteze tu hiyo kesi, lakini screenshot hapana, toka kwa simu yangu. So what you are saying is this: the first line, you give us the documents you are not willing to produce. So you are saying from our list, guys, the examiner will tell you sometimes, not sometimes, all the times, you will not draft these 2 documents together. Remember that. You will not draft all of them together. You will only draft one, because either you are acting for Bishar and you are the defendant, or you are acting for me and you're the plaintiff. Okay? So if you're the plaintiff, you will be told that your client requires to inspect this document. Proceed and draft the relevant document. And then you proceed and draft the notice to produce. And then you request for document 1, 2, 3, 4, 5. That is the first instance. The second instance, you are now acting for the defendant, and you're being told that the defendant, who is your client, has received a notice to produce from the plaintiff requesting to produce the following documents, this, and this. However, after conversation with your client has told you he's not willing to produce the copies of emails and the screenshot, but is open to have inspection on the rest of the documents. Please proceed and prepare the relevant document. In that instance, you prepare a notice to inspect, but at the back of your mind, you know, I'm preparing a notice to inspect, but my client has said no revealing the screenshot, no copy of email. So you prepare and say, take notice that the defendant objects to the inspection of the following documents. Okay, the following documents. And then the next thing is screenshots, copies of the emails, and then the screenshots. And then after that, you give us now the second line. Which documents are you willing to produce? And then you are saying, take notice that the defendant shall allow the inspection of the following documents. And then you tell them, if you are allowing, you tell them where and when shall allow the inspection of the following documents on the 2nd day of March 2024 at the defendant's office. So you come and view them. Which documents are these? Let us go. Number 1, in our list, they were giving us everything else, which is which is the demand letter together with the employment contract. So you come here and just indicate there. Sorry. So you're going to have the employment contract. So the three. Are you together? So this is what you prepare and you send to me. Okay. So that is Bishara has responded or through their advocates, drawn and filed by to be served upon. Full stop. Okay. Full stop. Are you together? That is how you prepare a notice to inspect. If you're responding to a notice to produce, inspect. So you can only draft one. Don't get it confused. You can only act for one party. However, guys, the examiner cannot tell you to draft. They can tell you, hey, advise. This person wants to inspect. Advise them on the procedure. So that means you first advise that, okay, you will send out a notice of inspection, a notice to produce having the following documents, okay? Now, when you do that, the other party will respond by a notice to inspect, highlighting the documents they will be allowing you to inspect and those that they will not be allowing you to inspect. Full stop. So you put your words in that paraphrased information I've given you, and then you get your full marks. Sometimes it's not about drafting. Sometimes you just give the information on the procedure. So the first procedure is send out a notice to inspect. So a notice to produce, and then the person will respond with a notice to inspect. Are you together? Perfect, 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 perfect. Perfect, perfect, and perfect, and perfect. Okay? Now, let us go to something else. Now, what if I am so interested in seeing the screenshots? Bishara said, hapana, hii screenshot utabidi mongoja mpaka nikufe. Na hizi emails sipeani. So what am I supposed to do? As the person that requested for them, I make an application to court to compel. So if the defendant or the plaintiff has refused to discover, has refused to give you the documents, then you go to court and you make an application to compel him to produce the following documents, okay? That application is made in a notice of motion and a supporting affidavit. And of course, it is usually under Order 14 of the usual orders that we talk about. So what is the prayer? That the court do issue an order compelling, okay? Compelling the defendant, if the defendant is the one that is refusing, or the plaintiff, to produce the following documents for inspection. 1, copies of emails from 3rd September to 20th of September, and the screenshot conversation between him and his wife. Okay? Maybe it is your wife now suing you, or your side chick suing you in a divorce proceeding. So you have to remove the screenshots. Before we divide the property, we need to see what you've been saying out there. You know? You've been talking to people. Now produce the screenshot. Okay, so you go to court and you make an application and you ask the court to compel him to produce. Okay, and of course your grounds are usually very obvious that those documents are relevant, that they're relevant to the suit and you want them to be produced, and that of course that the defendant has refused to produce the documents for inspection. That is the same thing. You only pray for one thing, okay, that the plaintiff or the defendant to be compelled to produce the following documents, and you pray for cost, and then your grounds from the question, and then you go write your supporting affidavit. Okay, now once you make that application, once I make application, notice of motion, okay, asking the court to compel Bishar to produce the documents, I will serve it upon, I will file it in court and I'll serve Bishar. What is Bishar supposed to do? What is Bishar supposed to reply? To file. What is Bishar filing?
Bishar will file a replying affidavit.
Yes, Bishar will file a replying affidavit. So anytime you're served with a notice of motion or any application, you prepare a replying affidavit. Now, in his replying affidavit, Bishar will say, no way, this information is not going to leave my phone, and he will give us the reasons in that affidavit. So anytime somebody has been served with an application, you respond by a notice, a replying affidavit. So guys, in this entire story, there are a few things I need to understand. First, understand who your client is. Are you representing the person that wants the document, or are you representing the person that is supposed to produce the document? If you're representing the person that wants the document, then the first thing is you prepare a notice to produce. Okay? If you're representing the person that is supposed to produce, you prepare a notice to inspect. Now, if there's a matter in court, if your client, if this person has refused to inspect, to produce the document for inspection, then if you're representing the person that wanted the document, you go to court by notice of motion and supporting affidavit, and you seek for orders compelling him to produce. Okay? If you are representing the other party and you've been served with a notice with an application compelling your client to produce, you respond by preparing a replying affidavit. Okay? Now, lastly on inspection, what are some of the grounds you can use to fight inspection? What are some of the grounds you can use to refuse inspection? There's a question in 2020, between 2021 November to 2023 November. Not November. It wasn't in November. 2023 March. There's a question in there that talks about the exact thing I'm saying. I will get it. It is a question 6. No, question 5 and a question 5B. If somebody has it, you will send it to me. Now, my question is this. What are some of the reasons you can use to refuse to produce a document? You've been compelled to produce. Now, what are some of the reasons you can put forth to refuse inspection? Number 1, the obvious things. If I want the screenshot between you and your person, and
yeah, you say that maybe the document.
Put your hand up. Who is that?
Oh, sorry,
Your hand should be up. Mikono lazima zikuwe juu. Everyone, guys, these are simple things. If somebody wants a document from you and want to give them, what are some of the reasons you can put forth? I will not proceed until I see hands. Manga Janine.
That the documents are not in your possession.
Thank you very much. That's a very good answer. I don't have the documents. Sina, what you want, I don't have them. Okay, that is a good reason to refuse inspection. So when you're drafting, you are replying affidavit. When you're drafting, remember, when you prepare your notice to inspect, you will just say that I will not produce the following. You don't give them the reason why. You just tell them I will not produce. But now when you prepare your replying affidavit, you'll be saying the document that is looking for, I don't have them. Number 2, Getangita. Is it Getangita or Getangita or Gitanjita?
Getangita.
Where are you from, Getangita?
We have, I'm from around.
Yeah, your name is around.
Yeah.
Answer the question.
We have incriminating documents.
Yes, you'll be saying that those documents are incriminating. They're self-incriminating. So if I produce them, they will incriminate me. That is a good reason. Thank you very much. Omondi Rachel, what is another reason why you can refuse?
Giving out the documents is an infringement of your right to privacy.
No, that's not a good reason. Give me a good reason. Which is still related to privacy. Ipsuge. What?
Privileged.
The documents are privileged.
Yes, those documents are privileged. What is a privileged document? Communication between you and your wife, communication between you and your wife, communication between you and your advocate and your client. Those are privileged communication. Okay, privileged communication. That the document is privileged. Getangita. You want to still up, guys?
Okay. We have marital communication document.
That is still privilege.
Oh, sure.
Somebody else? Yes, Ibrahim Bishar.
Documents are classified and sensitive for security.
So give me the wording. The wording is national.
National security is subject to the national security.
Yeah, that the Getangita mute. So the documents are producing the documents will be adverse to national security. Someone else, tell me. Yes, Stella.
Can we talk about protection of third-party data because of the Data Protection Act?
Yes, you can say that. Third-party information, data protection. That is a good reason. Yes, Diana Kipsuge.
If you are already in possession of the documents.
Yes, thank you. Whatever you are asking me, you already have them. You already have what you're asking. Okay? That is a good reason as well. Confidentiality. What is the difference between confidentiality and privilege? Guys, some of you confuse this thing in professional ethics. What is the difference between what is privilege and what is confidential? Okay? Who is protected by confidentiality and who is protected by privilege? So privilege, yes. Confidentiality as well, yes. Fishing expedition. That you are whatever you're looking for, you're just fishing. There's nothing you're going to achieve in this process. You're simply fishing for information. Okay. Another one is the documents are not relevant. They are not relevant in this case. They're not relevant. Okay. You want communication between me and my wife. How? How is it relevant in this case? Okay. So those are reasons you will have in your affidavit. I mean, in your replying affidavit as you respond to inspection. Are we together? All right. So that is inspection. That we are done with inspection. Very, very easy. Let us go to interrogatories. Interrogatories is very easy. I just mentioned two things in 2 minutes so that we can close the meetings. It's a long one. So when it comes to interrogatories, when you want to produce facts, when you want to inspect, not inspect, but if you want to discover facts, if you want to discover facts from somebody, they have facts, you want them to tell you more. Remember, the rule is very simple. The rule is whatever somebody has told you, or whatever somebody has written in their pleadings is deemed to be enough. It is deemed to be enough. So that if you want them to say more, you have to go to court. Okay? You have to go to court and get an order of the court. Are you together? You have to get an order so that they can tell you more. So what am I saying essentially? That if you want to interrogate, okay, then you have to make an application and then ask the court to compel you to compel the other party to provide additional information, additional particulars, additional information on the following things. You write the things that you want them to tell you more on. So that is all about interrogatories. So guys, interrogatories, whatever you want, you have to make an application to court, notice of motion, and you are praying for the court to issue an order compelling the defendant or the plaintiff to provide additional facts on the following things or the following issues. Issue number 1, the date or the information regarding the accident. Issue number 2, the treatment or the details of the injury, details of ownership of the car. Okay, so that is what you provide, and then you pray for cost. And then you go to your grounds, which shall be the question, and then the affidavit. Very simple. Okay, so when it comes to inspection of documents, there are 2 things. The first thing, prepare a notice to produce. They will respond by a notice to inspect. If you're not happy, that's when you go to court. Notice of motion, supporting affidavit to compel them. And then they will respond by a replying affidavit. The same way, if you want to get additional facts, interrogatories, you do what? You go to court direct. There's no notice to produce particular. You go to court direct and you ask the court to compel them to produce the facts on the following issues. You provide the issues. And then after that, if you are not happy, sorry, if they're not happy, they will respond by replying affidavit, whereby they'll be replying to your request for interrogatories, and they'll give reasons whether they agree or not agree. Okay, and of course, by the time you're making an application, it is already obvious that they don't agree. By the time you're making this application, it is already obvious that they don't agree. They don't want to produce anything. Okay. Okay, guys. So that is all for discovery and inspection. That is all for interlocutory applications. We have done all of them. The only thing that I will be doing now is to take questions starting from Mutinda Redemptor.
Good evening, Jackson. My question is, for discovery, do you go under a certificate of urgency? Because
no, it's not urgent.
What if they destroy the documents that you need to inspect?
What did you say about that?
Did we say anything? I can't remember.
Oh, Yesu mwana wa Yuda. You can't remember anything I said, or I didn't say anything. Guys, Redemptor, come back here. We just talked about when somebody is trying to destroy documents that you want. What do you do? Mutinda, come back here.
Go for orders.
Which orders? Can you...
Anton Pillar.
Mute your microphone. Mutinda, come back here.
I'm back.
I'm asking you a question.
Yeah.
What is the answer?
Oh, you go to court.
And sleep in court?
No, for Anton Pillar orders to search and see.
I say that. But I'm asking you now, and you're saying you didn't say anything.
Oh, sorry, forgot.
That is how you will forget. But on that day, kama kwenyu ni Wayakiwe, tajipata Kamulu, kama unatembea bila viatu, ukilia. Don't forget, my friend. Guys, I've said this, and I want you to understand that inspection is related to Anton Pillars, but by the time you are going to court, guys, this person, you already served him a notice to produce. Okay? So if by the time you're making an application to have him compelled, to produce the documents, then you know that he has the documents. Okay? And remember, he has responded. Amekwambia, hizi documents, I'm not willing to produce this one, and this one. So from there, you do your maths and you ask yourself, why is he not producing? Is he trying to destroy them? So if you have any doubt that he's trying to destroy them, then you don't get an order compelling them to produce. Okay, you just run to court directly and get Anton Pillar to go and seize them yourself and bring them before the court. Okay, but if they're not going to destroy them, because remember they will all say, oh, they're confidential and everything else. If they're not destroying them, then you don't need Anton Pillar. Anton Pillar is needed when they're trying to destroy them. So guys, do not forget, don't forget that, okay? Do not forget that simple thing. In terms of production of documents, inspection, and Anton Pillar, how do they relate? Where evidence is being destroyed, there is evidence that this person is going to destroy. You go through Anton Pillar. Okay, you go through Anton Pillar and you ask the court to issue an order that you go and seize the document. But if they have these documents in their custody, but they're just not willing to produce them, they're not destroying, of course, they will not destroy their title. There's some documents you can't destroy. They cannot destroy their titles. Okay? There's some documents that can't be destroyed. So if you want a title deed and they're not producing, they won't destroy them. So you only get an order to compel them. But if it is something that is going to be destroyed, evidence that is going to be destroyed. So guys, not every document will be destroyed. Okay? Some documents can't be destroyed. So if you feel like the document in this question is one that can be destroyed, then you go to court and ask the court to give you Anton Pillar. But if this is a document that they can't destroy, for instance, at a disputed title deed, they can't destroy that. You just compel them to produce. So guys, that is the thing. So there are two things. There's an instance where this person is just refusing to, to produce the documents, and there's an instance where they are trying to destroy. So if they're trying to destroy, Anton Pillar. If they're just refusing to produce, compel them to to produce. Kila kitu iko chonjo.
Thank you.
Is it chonjo Redemptor?
Yes, thank you.
Okay. Thank you very much. Let us talk to someone called Cheserek.
Hear me? Hello, can you hear me?
Yes.
Okay, so my question was about interrogatory. When do they apply? Why are we not just waiting for the day we are coming to court to interrogate the witness ourselves? Also, when you're seeking the prayers in the notice of motion, you talked about listing the issues. So perhaps you say something like that the court do issue an order compelling the defendant to avail themselves in court for an interrogation on the following issues. Which issues? Could you give us a sample?
Well, I didn't say to avail themselves in court. I just said that the defendant provide further particulars on the following issues, and then you list the issues. We listed the issues. For instance, number one, the details of the accident mentioned in the plaint, or the treatment details, or the title details of this XX motor vehicle. So where is that coming from? It will come from in a plaint. When you're reading a plaint, but the plaint is vague, okay? The plaint is vague. The plaint only says an accident occurred. It doesn't tell you which vehicle, who was driving, when did it occur, where it occurred. So you ask more, the details of the accident, number one. Number two, there could be a title in question. So you ask them to provide further particulars regarding that title. There could be a mention of some payment that was made. Somebody is claiming that he made some payment. and is not providing how much did he pay, who did he pay, you ask them to provide further particulars regarding that payment. So the particulars that you want will come from the question, and it is normally on issues that are not clear. Get what I'm saying? And it could be from the pleading. It could be from the pleadings. I mean, from both pleadings, from the plaintiff or from the defense, from the plaintiff or from the defense, or any document, even an application, even a petition. So long as the information is not clear, you ask them to come clear. Unaelewana?
Yes.
All right, sawa sawa. Let us talk to somebody called Isabel. That is the last question I can see.
Yes, Mwalimu, can you hear me?
Yes, I can.
Yes, I have a question, though it might sound basic. In instances where there's no pending case in the court, and maybe you gave your documents to someone, could be in their professional capacity or not, maybe an advocate, and you change your mind, you decided, okay, I do not proceed with this case, and you don't have any pending fees or something like that. But later on, they refuse to give you back these documents. And maybe they're originals, they're not copies. So in those instances, are you still going to try get back those documents through a production order or the Anton Pillar, or it's a totally different procedure?
No, that one, if they wanakuamilia documents zako, sue them. Sue them. That is not related to the case now. That is now a different suit. They have refused to give you. It's like somebody is having your money and is not refunding you. Unamfanyia nini? That is an entire thing. Somebody is having a laptop and they have refused to give you a laptop. You sue them. Plaint. Okay?
Thank you so much. Yes, yes.
Okay. And yes, we said there is no basic question. Every question is important. Ask as many questions as you want. Ask as many questions as you want so that you get the answer. Is the answer so that you are sorted. Anyway, I hope that you guys are fine. That has been a long class. Sorry for taking much of your time. It had to be done. Opande, yes.
How are you, Mwalimu? Mine is not a question.
Fine. Yes.
Mine is not a question, but how can I get you behind the tent?
My friend, you have my number. You can get me behind the tent. Sahi niliwaambia sahi bado sijakuwa senator. Nikikuwa senator, the first thing utaona hiyo group zote nitatoka, nitachange namba yangu. Ukikuja kuniona utakaa kwa lobby mpaka ushangae. Hata chai sitakupea kwa ofisi yangu. Utakaa na njaa. Sahi bado unaniona hapa. So take advantage kabla nikuwe governor. Utakuwa unasema tu kwa TV, huyu jamaa tulikuwa na yeye, alikuwa anatufunza, siku hizi ametusahau. Anza saa hii. Si ndio?
We'll look for you. We'll look for you.
Sawa. Anyway, my number is there. You can always reach out in case of anything.
Okay.
All right. Guys, that is it then. I think you guys, again, like I've said, it might sound like, yes, you understand it, but trust me, you don't. Go back, read on your own. If you wake up tomorrow morning and you are recalling what we've discussed today, then you understand. Okay, so go to bed now, wake up, try and recall what we've done today, and also read further so that you understand more and more. In the next class, we start on interlocutor. We start on pre-trial and the trial. We are moving very well. We are moving very, very well. So please, we shall be doing more and more and more and seeing more past papers as we go, so that everything is okay. All right, guys, I will see you next as we discuss the pretrial process, the case management conferences, and so on. Tomorrow is criminal. I will see you as we discuss and draft bail and bond policies as we get into the hearing stage. Please take care of yourself. Ask for the recording now, guys. Now is the best time to ask for the recording. If you don't ask for it now,